Morning, Your Honor. Matt Nagel for the people.
Jacob Riley on behalf of Mr. Chapman.
Today was the date and the time that was set for a jury trial. We have witnesses here today.
Is Tiara Richardson in the courtroom? I have checked around, Your Honor. I spoke to Tiara on Friday, but I have not seen her yet this morning. So at this time, the people are unable to proceed.
Given that fact, the next motion would be to dismiss.
A motion to dismiss is granted without prejudice, so that means that the people do have the right to reissue this against you. You understand that? Okay, we'll get you a copy of dismissal in just a moment. Yeah, this one matters for the record.
Not for this file. Thank you, Your Honor.
No, Your Honor.
You can have a seat, sir.
Your Honor, I don't know what the court would prefer, but I have witnesses present on Emanuel and Enright. We're just going to be asking that those continue to jury trial. And then as far as the remainder of the final three trials, I haven't seen witnesses, so that I expect the defense to make a motion. However, the court prefers to handle the docket with that information. Be ready when you are.
On the record in the matter of the people of the state of Michigan, this is Kenthny Emanuel 24-03232, counsel appearance.
Good morning, Your Honor. Matt Nagel for the people.
Jacob Riley on behalf of Mr. Enright.
So this is the date and the time that was set for a final pre-trial. And this matter is scheduled for jury trial March 31st. Is it continuing to trial?
That would be the people's preference. Yes, please, Your Honor.
Okay, Mr. Enright, do you have any questions for the court?
No, Your Honor.
Okay, we'll see you in person for jury trial, 8 a.m. March 31st. Any additional matters for the record?
Not for the people. Thank you, Your Honor.
No, Your Honor.
Here, you're all set.
The other one was Emanuel.
On the record in the matter of the people of the state of Michigan versus Kenthny Emanuel 22-03337, counsel appearance.
Good morning, Your Honor. Matt Nagel for the people.
Jacob Riley on behalf of Mr. Emanuel. Mr. Emanuel. I did speak to Mr. Emanuel on the phone last week, so I was expecting him to be here today.
You spoke with him when?
On Friday.
Record in the matter of the people of the state of Michigan versus Marcel Carter 24-02196. Appearance, please.
Good morning, Your Honor. Matt Nagel for the people.
And Luke Goodrich from the Public Defender's Office, here to represent Mr. Carter, who is standing to my right.
Okay, today was the date and time set for final pre-trial. The matter is scheduled for a jury trial March 24 at 8 a.m. Are we continuing the trial?
Your Honor, a necessary witness is not present this morning, therefore the people are unable to proceed. I expect the defense to make a motion.
That is correct, Your Honor. The defense should move at this time to have this matter dismissed.
Motion to dismiss is granted without prejudice. The people who have the right to reissue this against you. Do you have any questions, sir?
Yeah, after this, what I'm supposed to do with this?
You go back down to Ingham County and they will remove it. Okay. I will get you a copy of dismissal in just a moment. You're all set. On the record in the matter of the people of the state of Michigan versus Jessica Cortez, 24-03588. Appearance, please.
Good morning, Your Honor. Matt Nagel for the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Cortez, who is approaching counsel table now.
Time set for final trial. This is scheduled for jury trial March 24th, 8 o'clock in the morning. Are we continuing to trial on this?
Your Honor, necessary witness is not present this morning, therefore people are unable to proceed. I expect defense to make a motion.
That's correct, Your Honor. Given that, I would make a motion to dismiss today.
Dismiss is granted without prejudice. The people can reissue this against you. Do you have any questions about that?
No, Your Honor.
Okay, we'll get you a copy of dismissal in just a moment. Any additional matters for the record?
Not for the people. Thank you.
Nothing further. Thank you.
Well, the state of Michigan versus Nigeria, Courtland, 24-03695. Appearance, please.
Matt Nagel for the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Courtland, standing to my right.
Okay, Ms. Courtland. Scheduled for final pretrial hearing. We have witnesses here.
Your Honor, necessary witness is not present this morning, therefore I expect, and the people are unable to proceed, therefore I expect defense to make a motion.
That's correct, Your Honor. I would make a motion to dismiss today based on that information.
Your motion is granted without prejudice. Been here, I said it 5 times, so I'm sure you know what that means, without prejudice at this point, correct?
Oh, can you tell me what it entitles exactly?
It means that they have the right to reissue the charge against you within the statutory time frame, okay?
Okay.
And you can have further discussion with your attorney off the record about what that statutory time frame is if you have questions about that, okay? Do you have any questions for the court?
Yeah.
We'll get you a copy of dismissal in just a moment, okay? You're welcome. On the record, in the matter of the people of the state of Michigan versus Daniel Black, 24-03433, counsel appearance.
Good morning, Your Honor. Matt Nagel for the people.
Good morning, Your Honor. Mark Hunting on behalf of Mr. Black.
This matter was scheduled for a pretrial today. This is for operating while intoxicated. It looks like there was an offer previously extended for impaired driving. How are we proceeding today?
Your Honor, that's accurate. That was extended at the last pretrial conference. There was some additional discovery that was shared that I needed to review prior to making a decision. I've spoken to Mr. Black this morning. It's our intention to accept that offer. And if the court would like, enter a plea this morning.
Mr. Black, you unmute your device. If you want to accept the offer and plead guilty today to to impaired driving.
Yes, Your Honor.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give is the truth and the whole truth under the penalty of perjury?
I did.
Okay. Put your hand down. Okay, you have the following rights that you would need to give up if you wanted to plead guilty. First is your right to the presumption of innocence. So you're innocent until proven guilty. You have the right to require that the prosecution prove your guilt at trial by proving each element of the charge being brought against you beyond a reasonable doubt. You understand those rights?
Yes, Your Honor.
You also have the right to see, hear, or question or cross-examine in court any of the witnesses the prosecution intends to call to testify against you at your trial. You have the right to have witnesses subpoenaed to testify for you at your trial. You can remain silent and not have silence be used against you. You can waive your silence and testify at your own trial if you'd like. You understand all of those rights that you'd be giving up?
Yes, Your Honor.
Anyone threatening you to get you to give these rights up?
No, Your Honor.
The promise is being extended to you if you give up these rights and plead guilty to the amended charge.
No, Your Honor.
Are you currently on probation or on parole?
No, Your Honor.
You understand that by pleading guilty, it could result in a conviction that may have impact on your ability to travel outside this country or to get immigration status somewhere. You understand that?
Yes, Your Honor.
Okay, it also could be a conviction that you may need to report to your current employer, or you may need to place this conviction on a future job application. You understand that?
Yes, Your Honor.
Okay, as to the amended charge of impaired driving, how do you plead?
Guilty.
Factual basis, counsel?
Your Honor, would you like me to do it?
That's correct.
Okay. Mr. Black, on or about November 17th of 2024, were you operating a motor vehicle in the city of Lansing in Ingham County, Michigan?
Yeah.
Prior to operating that motor vehicle, had you consumed alcohol or intoxicating beverages of some sort?
Yes.
And were you pulled over by the police?
Yeah.
Ultimately, did the police ask you to take a blood test?
Yes.
And do you dispute that the results of that blood test were 0.127?
No.
And was it at least 0.127 at the time that you were operating that motor vehicle?
Yeah.
I believe that satisfies its factual basis, Your Honor.
Any questions from the prosecution?
No, Your Honor, thank you.
The court is satisfied with the factual basis. I'll accept your plea. I find your plea be made freely, voluntarily, and intelligently. This matter is scheduled for sentencing April 7th at 9 o'clock in the morning. Mr. Black, you need to report to our probation department in person within the next 48 hours.
Your Honor, if I might, I am virtually certain that I am unavailable on April 7th. Can we get it either the week prior or the week after?
March 31st at 9.
March 31st at 9 a.m.
Fantastic. Thank you.
No problem. Okay, and so again, Mr. Black, you need to report to our probation department here in City Hall in Lansing within 48 hours in person, okay?
Okay.
They'll get you scheduled and set up for a pre-sentence interview. If you have not undergone a substance abuse assessment by one of our qualified assessors, you will be required to do so prior to sentencing, okay?
Okay.
You have any questions for the court today, Mr. Black?
No, Your Honor.
Any additional matters for the record, counsel?
No, Your Honor, thank you.
No, Your Honor.
Thank you, you're all set.
Dan, I'll give you a call.
Good. Thank you.
On the record in the matter of the people of the state of Michigan versus Gabriel Jones, 25-00118, counsel appearance.
Good morning, Your Honor. Matt Nagel for the people.
Jacob Riley on behalf of Mr. Jones.
Okay, Mr. Jones is here. This is a pre-trial for a assault and battery. Was there an offer on this?
There is no offer at this time, Your Honor. I think it might be prudent to set this on trial and jury trial.
That would be our request as well.
Retrial March 3rd at 8 a.m. Trial April 7th at 8 a.m.
Okay, final pre-trial, March 3rd, 8 o'clock in the morning, in person at the court. And then your jury trial will be April 7th, 8 a.m. in person at the court. Do you have any questions at this time?
No, Your Honor.
Okay, we're gonna get you a copy of your notices to appear. You'll remain in contact with your attorney, okay?
Yes.
Any additional matters for the record, counsel?
Not for the people, thank you.
No, Your Honor.
We're all set, sir. You can have a seat until we get the notice. This is the matter of the people of the state of Michigan versus James Merill, 23-0347. Appearance, please.
Good morning, Your Honor. Matt Nagel for the people.
Jacob Riley on behalf of Mr. Merrill.
Mr. Merill has a breaking and entering without owner permission scheduled for pre-trial today. Was there an offer on this?
There's no offer at this time, Your Honor.
Request would be that this be set for final pre-trial.
Pre-trial March 3rd at 8 a.m. Jury trial April 7th.
Final pre-trial, March 3rd. You must appear in person at the court for that. And then your jury trial will be April 7th in person at the court. Both of them at 8 o'clock in the morning, okay? We're gonna get you your notice to appear. Do you have any questions at this time? Any additional matters for the record, counsel?
No, Your Honor.
No, Your Honor.
Oh, you're all set. We'll get you a notice in just a moment. On the record, in the matter of the people of the state of Michigan versus Jeremy Morgan, 24-02882. Sir, why are you sitting in my courtroom with the hood and hat on?
Good morning, Your Honor. Matt Nagel for the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Morgan. I reached out to him last week, but I haven't made contact and I don't believe I've seen him here this morning.
No problem.
Because this offense is assaultive in nature, Your Honor, the people will be requesting a bench warrant.
Post your bench warrant and bond forfeiture. No problem.
Oh. Yeah.
Daniel Devlager here.
These are also just so the court is where Kenthny Emanuel just arrived in the courtroom. He was in the final three trials earlier that hadn't arrived.
Is that who was sitting in the back with the hood on?
That was Mr. Emanuel, yes, Your Honor.
On the record of the matter, the people of the state of Michigan versus Daniel Devlager, 24-03104. Counsel appearance.
Good morning, Your Honor. Matt Nagel for the people.
Jacob Riley on behalf of Mr. Devlin.
Okay, so Devlager was scheduled today for sentencing. I have a pre-sentence report that was prepared on the 13th of January. Counsel, did you get a copy?
We did, Your Honor.
You need to make corrections, updates, or deletions.
There's one correction, Your Honor, to the employment status. My client is no longer working at the Burger King, and he's beginning a new job at a Wendy's on Cedar Street in Enright. Other than that, I believe the report can be actually accurate.
What about the portion of the report that says he has a bench warrant?
Understanding is that this is the district where my client is currently on probation supervision. He's in contact with the probation officer there. It's a warrant for some back fines and costs. I think he's working with probation to get that cleared up, but at this point, I think there is technically a warrant active at this time.
What does it entail working with probation to get a bench warrant? That's
With my client, I know that he's been reporting to his probation officer there, and they have not ordered him to turn himself in or anything of that nature. So I don't know if they want to take into custody in that warrant.
if I issue you a bench warrant, probation has nothing to do with my bench warrant. Why haven't you turned yourself in on the warrant?
It's all the way to Muskegon. I can't go all the way there. I've been reporting as I'm supposed to.
You report virtually?
No, in person. I actually have to report today.
In Muskegon?
No, here.
Okay, so it's your probation is here?
Yes, Your Honor.
So they transferred it
Supervision.
to your supervision here?
Yes, Your Honor.
Okay, and have you contacted the clerk's office in
Yes, Your Honor.
Muskegon to see if they will arraign you on the bench warrant virtually?
I contacted them about the fine. They said, as soon as I get a payment, I gotta pay the 435 now. It was 420.
I recognize that you probably have a failure to pay bench warrant, but the issue is when you're lingering outside freely, when there's a warrant, any interaction with law enforcement requires you to go into custody. And so you want the warrant cleared. If it's a failure to pay, you could likely get it cleared by making a promise to pay a payment plan. And so that's what my question is. Did you contact the clerk's office to see if you can have a virtual arraignment of that
No, Your Honor.
But that's what you need to do.
Yes, ma'am.
Your attorney should have advised you to do that too.
Yes, ma'am.
Don't talk to probation, that they didn't issue the bench warrant. Call the criminal clerk's office. Let them know you're on probation because of, I'm assuming because of where you live, you report down here. And you have no way to get out there, but you want to enter a payment plan to clear up the bench warrant. You don't want to be outside with the bench warrant.
Yes, ma'am.
You understand that?
Yes, Your Honor.
Okay. Counsel, you can make allocution on the
Your Honor, I think,
sentencing.
to begin with, I think the recommendations of the pre-sentence report are fair. My client certainly regretful about this incident. He certainly did not mean to cause anyone harm, but he understands that he did likely cause some fear, some nervousness about his intentions, and it certainly is not something he wants to do. He knows he can't be running around with weapons like this. And I don't think this is an incident that's going to repeat itself going forward. Certainly, my client wants to finish out his probation out of the 60th district, complete his obligations to this court. I don't think he's going to have ongoing problems with the law once that is complete.
Okay, this was, I'm just refreshing my recollection. This was the matter that took place at LCC.
Yes, Your Honor.
Did your client want to make a statement at all?
No, Your Honor.
The sentence report and the recommendation, I think it's appropriate as well, that a term of probation with some programming is appropriate.
Your Honor, may I speak about some?
Actually, did you want to make a statement? You said no, so you changed your mind.
I have been actually volunteering at Kristen Ray Community Center, free will. Also was trying to do Abbott House, but they, I guess, had too many workers, so I didn't.
Very good. It's good to participate in community service of your own free will. That's why it's volunteer work. You're supposed to volunteer, not be told. Otherwise, it's not technically volunteer. It's court ordered if that happens. But nonetheless, I think it's good. It's good for you, especially if you have some extra time, which, are you still in school?
Your Honor, I graduated.
Okay.
I can't go back to OCC until September 27th this year.
You say you can't go back where?
To OCC until September 27th this year, I believe.
But you just told me you graduated. Where would you go back?
Yeah, high school.
Okay, but I was actually were you in school because this incident took place while you were a student at LCC,
Yes.
correct? Okay, so you're suspended from LCC
Yes.
and they gave you the suspension until when?
September 27th this year.
Okay, so it's good for you to spend some extra time doing some community service, keeping yourself engaged and staying out of trouble until you can get back in school. I'm going to adopt the recommendation. You will be sentenced to a term of 6 months probation. While on probation, you have the following conditions. You need to maintain employment and provide evidence of that to our probation department. You are required to participate in moral recognition therapy. And you'll continue your group meetings for your mental health treatment, okay?
Yes, Your Honor.
Also, while out on probation, you're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You understand that?
Yes, Your Honor.
You're not to use alcohol, marijuana, or controlled substance unless you have a valid prescription. You understand that?
Yes, Your Honor, I don't do that anymore.
Very good. And you will be required to submit to random preliminary breath testing and urinalysis testing. You're responsible for the cost associated with that, okay?
Yes, Your Honor.
And then you're not to be at any bars or nightclubs while on probation.
Yes,
Yeah,
Your Honor, I'm not old enough to do that.
very good. Well, it's very good. Looks like you're already on the right track on most of these, okay? Okay, let's see here. As to fines and costs, there is a $75 crime victim rights fee that will be assessed, plus a $50 state minimum cost. I'm going to waive discretionary fines and costs. However, there's a $30 per month probation oversight fee that you must pay. And so that's $180. So your total fines and costs with probation and oversight is $305, and you'll make monthly payments on that, okay?
Yes, Your Honor. Is that gonna be in, what's this, like the money payments or like the money orders or?
You can
a
make
check
payment via cash, credit card. You just, if you want to make it in person, you come up to the criminal traffic window, make your payments there, okay?
Okay, so I can't do it in cash too?
You can do it in cash too. They'll, you come up, pay in cash, they'll give you a receipt, okay?
Yes, Your Honor.
Okay, and so, but you'll be required to make monthly payments on that, okay? You have any questions about that?
No, Your Honor.
Lastly, I have here an advice of rights as to probation and states you've been placed on a term of probation before the 54A District Court, and your terms are specifically tailored to address your assessed risks and needs. You would be eligible to request early discharge from probation once you complete half the original term ordered by the court, so long as you've not violated your probation within the 90 days prior to your request, okay?
Yes, Your Honor.
You make that request by using the court's MC 512 form that's on the court website, or you can just ask your probation officer for a copy, or your probation officer can submit the request on their own, on your behalf. If you submit the request, it's your responsibility to get a copy of that to probation, and then you must also serve a copy of it on the prosecutor's office. The prosecutor would have 14 days to respond in writing if they object to your early discharge, okay?
Yes, Your Honor.
If I set it for hearing, which I've never set one for hearing, but yours could potentially be the first one, you never know. If it's set for hearing, you have the right to hire an attorney to represent you. You do not have the right to court-appointed counsel to represent you for early discharge hearing. Do you have any questions about those rights?
No, Your Honor.
Initial that you received, and I went over that with you. Okay, you'll check in with our probation officer before you leave, which is on 1 floor down from here, okay? Any additional matters for the record?
Your Honor. No, Your Honor.
You're all set, good luck to you, sir. Did we get that man his notice of fear? Is it Mr. Merrill? Were you waiting for something, sir?
I was waiting to speak.
Oh, waiting for your turn. Okay, very good.
Yeah.
Okay.
Blackman is on Carlton Donald.
By the way, this was March 24th, right?
And Nathan, he's right on his way, was the first thing.
Sounds good. This guy's in custody. On the record in the matter of the people of the state of Michigan versus Tiara Richardson, 24-01372. Council appearance.
Morning, Your Honor, Matt Miller for the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Ms. Richardson, who is standing to my right.
Okay, Ms. Richardson, the schedule for sentencing today. Okay, I have a pre-sentence report. It was prepared on the 5th of February. Council, you got a copy of that?
Yes, Your Honor.
And I am assuming you went over with your client any changes to the recommendations or
Yep.
updates.
There are no corrections or updates at this time, Your Honor.
Okay, you can make allocation.
Thank you, Your Honor. Ms. Richardson is someone I've talked to a lot during the pendency of this case, and she has been someone who is consistently upfront and frank with me about what her priorities are. And at each and every turn in this case, her priority has always been her child. Her most constant question to me, or her most regular question to me is she okay? How can I make sure she's okay? What can I do to make sure my daughter is okay? And I think that's a priority that kind of defines who Ms. Richardson is, and I think that's a positive priority. To that end, she's been willing to engage in anything and everything that's a suggestion of the court, often bringing up these suggestions herself, which I think is how we kind of arrived at a family counseling or family therapy program. That was a conversation that she suggested to me that I then brought up with Mr. Markarian some time ago. And I think it's a fair recommendation here in the order for today. Ms. Richardson has been timely to all of her court dates, timely in communications with me, and I have every belief and faith that is going to continue on any term of probation. I think she's looking forward to the counseling. She's trying to seek it herself, and it can be hard to get into with timelines. And so she's looking forward to possibly the court being able to help her get into those classes that she so badly wants to get into for both her and her child's sake. I would ask the court to adopt the recommendation. I believe Mr. Hanna indicated there was a 6-month term of probation recommended with family therapy counseling being the primary goal on probation, as well as the granting of the specialty status 76948, which Ms. Richardson does appear to be eligible for. And I would ask the court to adopt that recommendation. The only thing I believe I'd ask the court to amend here is there is the boxes checked for submit to random PBTs or urinalysis. I don't know that that's a necessary requirement for Ms. Richardson. I don't think that is something that she in particular contends with. I think her issue has been in the past of trying to figure out how to parent well in terms of how to control or maintain her own frustrations when she's dealing with another young individual who's frustrated. I don't think alcohol or substances is something that feeds into that in particular. And this just becomes a quite frankly, can be overwhelming cost for people for doing that on a regular basis. So that is the only thing I would ask the court to amend here is to remove that submission to PBTs. Thank you.
Did you find one state?
No.
I reviewed the pre-sentence report and the recommendation. Hey, the recommendation and the body of the report is actually for 8 months of probation, not 6 months.
Oh, I'm sorry. You wrote 6 on the
I
recommendation sheet.
Agreed. That is on the recommendation sheet, but in the body of the report, it took 8 months. And also discusses the need to continue some family therapy, and how you thought that it's been beneficial to you. Obviously, I think in this circumstance, we were talking about mother and daughter parenting, that your daughter's a teenager.
Yeah.
Challenging years, of course. I don't think any of us have gone through our teenage years without causing some level of angst to our parents, sometimes more than others. And I recognize too, even in this generation. They're not like the generation I came up in. I'm sure they're not like the generation you came up in. They're dealing with different challenges. They're exposed to different things that I would never have been exposed to growing up. I didn't grow up with access to social media because there was no social media, or walking around with a little computer all day long, and things that were maybe jokes or bullying during the day didn't later go viral amongst my peers. So the pressure for acceptance wasn't what it was now then, because social media has magnified everything. Having access to this digital device has impacted even the development of a child's brain. There's countless research that shows and tells and explains what happens to an adolescent's brain or a child's brain when they're exposed or overexposed to media, not just social media, just the use of a phone or an iPad or technology and what that does to their development. And so it definitely has an impact on them. And so you're rearing a child and trying to navigate how to counsel them through things that you didn't actually have to go through at their age. So sometimes it's difficult to understand and put yourself in their position. I think counseling could be helpful for that, so that you can still be stern, still be a disciplinarian when it's appropriate, but not to the level that rises to an abusive nature. You're supposed to be first line of defense for your child. You're their protector. And so you want to create an environment where she feels comfortable and safe coming to you to talk about what she's going through, even though it may not be something that you may agree with, or that something that could possibly get her, reprimanded or punished for. You don't want her hiding those things or seeking a refuge outside of you. So I think counseling could be helpful to help you all mend that relationship, rebuild that trust that's needed there, and move forward so that we don't have these kind of incidents and you won't be back before this court. Also, what wasn't stated, but I think the report does address it, is you are eligible for sentencing under 769.4A. So I am going to place you on a term of probation under 769.4A, which will make this non-public on your record after you can successfully complete probation, okay? There is, you're not employed?
I am.
Oh, you are employed?
She works at the City Rescue Mission, Your Honor. She's also seeking a second job. That isn't guaranteed yet, so she'll be keeping probation updated with that. But she is employed part-time at the City Rescue Mission in the security department right now.
Okay. Okay, so I'll put you on a term of probation while on probation, and even though the report says 8, we're gonna do 6 months probation. While on probation, you're not to engage in any assaultive or threatening behavior. You're not to purchase or possess a firearm, ammunition, or weapon of any kind. You're not to use or possess alcohol, marijuana, or drugs unless you have a valid prescription. And you're not to be at any bars or nightclubs. Do you have any questions about that?
I do have a question. When you say after the 6 months, I would be able to be under that special parole. Will I not be able? So I have a healthcare administration degree, and I can't apply for jobs with this type of thing on my record. Would it show now?
So it's currently.
Yeah, once I grant it and they put it in the system, it'll go in as non-public. So even if there was some reason that we need to address you on the record after this, for any reason related to your probation, it would be non-public. I would have to clear the courtroom out and everything. So it immediately goes non-public once they put it in there, okay? And you'll maintain that status so long as you don't do something to get you revoked from it, okay?
Okay. And then also, her birthday is like Monday, and she wants to go to like the Black Rock, and that's kind of like a bar, grill type of thing? Am I not
It's a
allowed?
restaurant.
It's a restaurant?
Yeah, restaurants have bars, so. Yeah, Black Rock is where you cook your food in front of you.
Yeah.
Yeah, it's a restaurant.
Okay,
Yeah, no, that doesn't count.
okay,
Yeah, I'm talking about like Duke Saloon. Yeah, yeah, stuff like that.
not worried about that.
Agreed.
I don't hang out.
Agreed. Yeah, that's what we're talking about. Not, most restaurants have bars. That's not what we're talking
Okay,
about. Okay, I am not gonna order the testing.
Thank you.
And so it just advising you of the, not to use substances unless you have a valid prescription. No clubs and bars. Doesn't sound like that's an issue for you. And so then also you will continue some family therapy. And if you're not already enrolled in some, you can talk to your probation officer for some recommendations, okay?
okay.
And you'll maintain employment and provide evidence of that to your probation officer as well. Do you have any questions at this time?
No,
Okay, let's see. It's a $75 crime victim rights fee that must be assessed, as well as a $50 state minimum cost per statute that also must be assessed. I'm gonna waive discretionary fines and costs. And there is a $30 per month oversight fee that you will have to pay for probation. So that's $180. So your total fines and costs are $305. You'll make monthly payments on that. And let's see. Lastly, there's an advice of rights as to probation. States you've been placed on the term of probation before the 54A district court. Your terms are specifically tailored to address your assessed risks and needs. And so if you were not on a term of probation for domestic violence, you would be eligible for early discharge, but you are on a term of probation for domestic violence. So you do not get to make that request for early discharge. You understand that? Okay. And so, however, I will note here. That if I don't have any issues and you're compliant within the first 90 days, that this will convert to non-reporting for the last 90 days. And then we'll waive the oversight fee, okay, for the remaining time. Do you have any questions about that? Any additional matters for today's meeting?
I have nothing further. Thank you.
You leave here, you'll check in down with probation before you leave, okay?
okay.
And good luck to you. Okay, is it Carlton Donald in custody? Downstairs?
Yes,
Yeah. Who's representing?
That's the black.
That's Mr. Black?
Yeah.
But on the sentencing?
You said that he's representing him on all of them. He's on the pre-trial for sure. He has a pre-trial at 10:30 and then.
Did we get a substitution? Because if we didn't get a substitution, then he's not representing. And his name is not on absolutely anything at 9 o'clock. Okay, well. Nothing's here. On the record in the matter of the people of the state of Michigan versus Kenthny Emanuel, 22-03337.
Good morning, Your Honor. Matt Nagel for the people.
Jacob Riley on behalf of Mr. Emanuel.
Mr. Emanuel, why were you late?
I fell asleep and I had to catch the bus. I stay right on the south side, but I will be.
I don't believe you had a witness, is that correct?
Pardon me, I'm sorry.
We didn't have a witness, did we?
We do, he's still here. Yes.
Oh, the witness is here. Okay. This was a final pre-trial?
Yes, Your Honor. I
Yes.
believe this is currently scheduled for a jury trial on March 24th, if I'm correct. So the people would just request that this remains set for trial.
Okay, we'll continue to trial. Mr. Emanuel, I'm going to emphasize that I have to be lenient today because we don't have to call on a jury. I can't do that on trial on jury day. We have to have you here to call the jury in, and we have a deadline by which we can call the jury in. And so you gotta set your alarm and get here on time, okay? Also, does your attorney have working contact information for you?
I might give you a number, 974-0967. Yeah, but that's where we looked at.
I've watched it, yes.
Okay. Sorry for being late. I apologize.
Your Honor, if I may, just for the record, the people have extended an offer in this to plead guilty to an amended count 1 attempt A and B with a Killebrew agreement to no upfront jail. It sounds like that offer has been communicated. The defendant is not prepared to accept that offer today. With the court's permission, the people would have no problem keeping that offer open between now and the jury trial date, but certainly the court would need to be informed prior to the jury trial.
When was he, this is the first time you heard this offer?
Yeah.
Yes, Your Honor.
I mean, as long as I don't get no jail time.
You don't have to accept the offer today, because you have until 1 week before the 24th to tell me if you want to accept the offer.
Wonderful, thank you, Your Honor.
You just can't wait for everybody to get all geared up, spend their weekends prepping for trial, and then come in here and decide, okay, I'm gonna plead. That's abuse. That's abusive. So I don't believe that you should have to take an offer the day you get it. You should think about it. Think about the ramifications. I heard you say something about getting jail time. The likelihood of you getting upfront jail time, slim. It does not mean that you're not facing jail time. And so that's still a consideration. And also, obviously, having a criminal conviction is something that you need to strongly consider. You don't take a plea just to get something resolved. When you plea, it has to be because you believe you are guilty. You understand that? And that you don't have a valid defense. So you talk to your attorney in private about that, okay? Any additional matters for the record?
No, Your Honor, thank you.
No, Your Honor.
You're all set.
You want this on the time?
Yeah.
Yeah, because it's a PR, it's a PRN, so.
Mr. Greer, can you hear us?
Yes, ma'am, I can hear you.
Okay, you can start your video, sir. Okay, on the record in the matter, the people of the state of Michigan versus Bernard Greer, 24-02997, council appearance.
Good morning, Your Honor. Matt Nagel for the people.
Jacob Riley on behalf of Mr. Greer.
Okay, Mr. Greer was scheduled in this matter for another pre-trial. Last time I checked, he was at a residential home. Let's see, I think we were resetting it so that contact could be made, but I'm not sure how we're proceeding on this matter.
At this time, we're going to ask that this be set for final pretrial.
Was there an offer at all?
There's no offer at this time, Your Honor. However, negotiations will continue between now and the final trial.
And then is Mr. Greer still at the house is what it's called?
He's at a different name for you in a second. It's now at Thomas L. Parkway.
Correct, that was what I was talking about, the house at 841 West Thomas Parker.
That is still where he's at.
Oh, it sounds good. Okay. Final pretrial.
March 3rd, 8 AM.
Your final pretrial is March 3rd at 8 AM. You must appear in person, okay? Looks like he's frozen. Mr. Greer, can you hear us? Okay, off the record.
So I'll reach out. With,
Mr. Blackman,
No,
hi. Are you representing Mr. Donald
Yeah.
on the sentencing matters too?
Yeah, but we have no pre-sentence report to do. So
I'll just talk to you.
The last one is there.
I have to hear it.
Okay, can you hear us now? You froze, sir.
Yeah, I got kicked out. I can hear you.
Okay, okay, back on the record for Mr. Greer. Let's see, we're gonna set your matter for final pretrial in person at the court March 3rd, okay? At 8 AM. Same time.
Say all that again, please. I didn't hear you.
You have to come to court in person on March 3rd at 8 AM, okay?
Okay.
Okay, I'm gonna try to arraign him, but he keeps freezing. Can you stay still, because I gotta try to arraign you on another matter, okay?
Okay.
Okay, I have the people of the city of Lansing versus Bernard Greer III. And this is file number 24-03184. I have a citation here that alleges that on or about October 14th, 2024 at 8:31 PM that you trespass at the area at or near 420 South Grand Ave at or near East Kalamazoo, which is the CATA station. The allegations that you trespass at CATA several times and keep returning admits to knowing he isn't allowed
Ma'am,
to be
what's
on
the
the.
address?
Sir, let me stop you because I don't want you to say anything on the record that could be used against you. Okay, let me complete the citation here. So this is a misdemeanor and the maximum penalty is 30 days in jail. Do you understand that? It's frozen again. Okay, well, we'll just arraign him when he comes.
Yes, ma'am, I do.
Okay, you have the right to counsel. Did you want to request court-appointed counsel for this?
Yes, I do.
Okay, we'll note that you're requesting court-appointed counsel. You do have court-appointed counsel in your other matter. He doesn't need to do a new intake, does he?
And we can kind of recycle the information we already have.
Okay. I'll issue a bond of $100 personal recognizance. And you're not to be at the CATA station. And your pretrial date on this is going to be February 25th at 9:30, okay?
Yes, ma'am. What is the court address?
The court address is 120 West Michigan Avenue. We're in City Hall,
120 West
Michigan Ave.
Michigan Ave. And can I get the dates again? It's March 3rd.
March 3rd, that's the date you have to appear in person at 8 a.m.
Okay.
And then the trespassing, you can appear via Zoom. That's on February 25th.
February 25th.
At
Okay, I'll be
9:30.
there at 9:30.
Do you have any questions?
No, ma'am.
Okay, any additional matters for the record, counsel?
No, Your Honor.
No, Your Honor.
You're all set, sir.
Okay.
Thank you. Cortez,
Yes, good morning, Your Honor.
good morning. Oh, he's here for Isidore.
Yes.
Is he logging in separately?
Oh, he's in the courtroom, Your Honor.
No, not this one.
What's the last name?
Isidore Uasinda.
We'll call it.
The jail is logging in. Let's see. Oh, okay, he was outside.
Okay.
Are you ready to go on the record on this matter, counsel?
Yes, I guess I am.
Okay, let's see, Mr. Blackman, what's going on here. This is old, right? That's what's happening.
And so when he was arraigned, they never
Did a new record.
well, they never alerted us so that we can do another. Give him enough time, honestly.
But he was arraigned on the 17th.
Yeah, last time.
And then he's got a new case. So 2021, they're old. Got it. No. Sentence referred to probation. Okay. He looks like he saw Jeff Buchanan far more times than he saw me.
I think it was her file.
Was it?
Why, or
Why do I have it?
even the front of the prison, I think that was.
Incident from 2018. Do you want us to bring him up?
Judge, you want to just reset this and, I mean, does he need a report on those things?
These are so old. What's the newest thing he's got going?
I think it was a felony.
Judge, we waived him over, if you remember, we waived him over,
Oh, he's got a felony.
that was a felony last Friday
Is he
morning.
being held on the felony?
Being held on the felony. Also, I have another felony in 55th District Court. We're doing a.
I'm gonna give him credit, time served on these.
Okay.
They're from 2018. I don't need an updated report.
Is a fleeing and attempt fleeing loose forth and a domestic?
Yeah, there's the, yes,
Yeah, the process from 2018.
yeah, from, yeah, it looks like.
Okay.
I arraigned him in 2020, January 2020 on that one.
Okay.
And then I have a DV. Again, that's the new one today, but it's from 2020, the new one. And then I have another sentencing. I mean, this actually does have a report, but it's from 2020. So, and he had 9 days then of credit. And that is again an incident from 2018. I can bring him up on these. We can bring up Donald. He's got a bigger fish to fry than this. Okay, and then let's see. I'll do this one. On the record, in the matter of the people of the state of Michigan versus Isidra Uasinda, 24-03092 SD. Appearance, please.
Matt Nagel for the people.
Jeff Cordis on behalf of Mr. Uachenda.
Agenda has a operating while intoxicated, second degree. The two counts. How are we proceeding on this?
Your Honor, we were here on December 16th, and we were going to have Mr. Uachenda screened for sobriety court. For some reason, I don't think that process has been fully completed. And I believe Mr. Nagel is the new prosecutor on this. So I guess I apologize for asking the court if we can have another just short adjournment to maybe finish this process.
No need to apologize. That's when we adjourned this a week before Christmas. I think we expected that it wouldn't be done when we did.
Okay.
I certainly have no objection to that, Your Honor. Sounds like if this is an OWI second, it sounds like we're gonna have to do the screening for 55th District Sobriety Court.
Correct.
Yes.
March 3rd at 10:30. Does March 3rd at 10:30 work?
It does.
Okay, well, we're set it for March 3rd at 10:30. Any additional matters for today's record?
No, Your Honor.
No, thank you.
You're all set. We'll get you a notice. Okay,
Thank you, Your Honor.
thank you. I see Mr. Scruggs is here. That's Mr. Quincy's file. Yeah.
I'm sorry, did you ask for appearance?
You are correct, it's Mr. Kunz's file.
This Mr. Coombs is on that file. Okay, I don't know who this is. Oh, Carissa Knight. Who's representing Carissa Knight?
I represent Kristen.
Do you need to speak to Carissa?
No, I need to speak to Mr. Knight.
Her audio's not even working. Hold up here.
Here, did Mr. Lucenda have his notice to appear? I can give it to him.
Well, I'm unaware of any. It's a DV. So tethers. Merill. What's the, I mean. They probably, it's a DV, so they probably did, the exclusions on, she just didn't hear it. Yeah, I never get it. I never got it either.
Okay. On the record, in the matters of the people of the state of Michigan versus Carlton Donald, have 18-06824, 20-00312, 18-06824 again, and then 21-00030. Council appearance.
Good morning, Your Honor. Matt Nagel for the people.
Your Honor, Fred Blackman on behalf of Mr. Donald, who's standing to my right at 40.
Okay, Mr. Donald, in file number 21-00030 has a domestic violence pending. I think my understanding is that we want another pretrial set.
Yes, Your Honor.
March 3rd at 10.
Judge, could we set a week after that? I'm going to be out of the country.
March 24th at 8:30. March 24th at 8:30.
Thank you, Judge.
This is not for a final pretrial, just a second pretrial.
Just a second.
Second
Control.
pretrial.
And then, let's see. For 20-00312, this matter was supposed to be set for sentencing. However, Judge Buchanan file and not mine.
No, I think she would just, she might have done the arraignment, Judge. I was looking at that
I
too.
did the arraignment, and it looks like she had a probable cause conference. She held that adjourned next week. It says on February 27, 2020, you took a plea before her. You're gonna waive your right to be sentenced by her today? Okay. I just had to address that because I didn't handle that plea. I just did the arraignment and issued the trial. So nonetheless, we don't have a PSI on that one. I'm not really sure why. And then I have another file, which was my file, I believe. And that one I inherited from Judge Clark. That one I do have a pre-sentence. What is this? Let's see. 18-0. Okay, yep, I have a PSI on that one. It looks like. What is the PA 53? From 2020. Okay, sounds good. I advise your attorney that due to the age of the cases, I don't think it's meaningful to send you to probation for a new pre-sentence report. You're being held on, I think, felony matters, correct?
Yeah, we just, as I indicated, court, we waived over the circuit court on the matter here, a weapons case, Judge, and then I have a prelim in a couple weeks, about a week and a half out at 55th on another felony count.
Okay, so the pre-sentence report that I have here is old. It was prepared, it looks like, back in 2020. At that time, you had 9 days credit. And then you've been at least in custody since the 17th of January this year. So I'm gonna credit you time served. Give me an update, but I'll let them calculate that for me. And whatever that is, you'll get credit for. Credit time served on that file, dismiss the PA 53. 2020. On the looting. Credit time, so. I think that resolves the sentencing matters. Any additional matters for the record today?
Nothing, Your Honor. Thank you.
Thank you.
And then object to the initial calls were. Was not-
Ron Roberts. Okay, your attorney is going to log in to meet with you in just a moment.
Okay, thank you.
Mr. Scruggs?
Yes.
Okay, we're just waiting for your attorney. The jail put you on early. You weren't supposed to be here until 10:30. Okay?
I was registered to get a buffer.
Oh, okay. Sounds good. Who's on the fire tablet? Okay, well, I'm gonna remove you since you're not responsive. Okay, on the record in the matter of the people of the state of Michigan versus Carissa Knight. This is file number 25-00094. Appearance, please.
Pat Nagel for the people.
Riley on behalf of Ms. Knight.
Okay, this was a matter scheduled for pretrial for domestic violence. You say you wanted to leave this set for final pretrial, or?
That would be our request, Your Honor, yes.
March 3rd at 8 AM.
March 3rd, 8 AM, in person at the court.
April 7th.
Your jury trial will be April 7th, 8 AM in person at the court. Ms. Knight, do you have any questions for the court today?
No, ma'am.
See you in person, March 3rd, 8 AM. Any additional matters for the record?
No, Your Honor.
No, Your Honor.
You're all set, Ms. Knight.
All right, have a good day.
Thank you. Okay. If there are, someone's on a fire tablet, they are telling me who they are.
Hey, Addie, may I ask you a favor, please?
Sure.
Get a moment on Desun Roberts, please.
Okay.
I'm gonna dismiss that.
Okay.
I have no idea how I'm gonna do it.
Yeah,
I can't put the father-in-law up there because he'll lie.
Yeah,
And so
neither one helps that.
I have no idea how I'm gonna.
Yeah, that's good. Okay, I'll go let him know number.
Can you unmute so I can know your name?
Can you hear me?
Yes. What's your name?
Name is Billy King.
Okay. Billy King. Do you know what your attorney's name is?
Just one second. His name is his name is Jacobs.
Jacob Raleigh.
Yes, ma'am.
Okay, sounds good.
What?
Hey, how are you doing?
Mr. Raleigh's client is here tonight. Tonight.
Kristen, I bet she was handled.
Oh, I'm sorry, not Knight. It was King, Billy King.
Okay, I'll let him know.
Did you tell Mr. Roberts on there? Your Honor, for Mr. Desun Roberts, I just signed and submitted a volley to Patty.
On the record, in the matter of the people of the state of Michigan versus Desun Roberts, 25-00160, council appearance.
Good morning, Your Honor. Matt Nagel for the people.
Good morning, Your Honor. Assistant Public Defender Lauren Sutter on behalf of Mr. Roberts, who joins us via Zoom.
Okay, Mr. Roberts, this matter was scheduled today for pretrial. This is for stolen property, receiving and concealing less than 200. Subsequent offense, and the people are moving to dismiss without prejudice. That's correct.
That's correct, Your Honor. Looking at the file, it looks like the people would be unable to support our burden if this were to proceed to a jury trial. So therefore, at this time, the people would make a motion to dismiss.
No objection.
Motion to dismiss is granted. So you'll get a copy of this dismissal in the mail. Okay, sir?
Okay, thank you very much, Your Honor.
Do you have any questions?
Nope.
Okay, you're all set. Thank you.
All right, thank you.
You're welcome.
Listen to this from the courtroom. I don't know if it's still playing the courtroom or not, but.
On the record, in the matter of the people of the state of Michigan versus Billy King, 25-00140, appearance, please.
Good morning, Your Honor. Matt Nagel for the people.
Jacob Raleigh on behalf of Mr. King.
Mr. King has a pretrial for child abuse, 4th degree. Was there an offer on this?
There's no offer at this time, Your Honor. I think it would be prudent to leave this, to have this set for a final pretrial and jury trial.
Let's see here. How old is the alleged child?
Major, I believe.
Okay.
14, 15.
Final pretrial March 3rd at 8 AM.
Final pretrial, March 3rd, 8 AM. You gotta appear in person.
Okay.
Trial
Jury trial, April 7th. 8 a.m. Jury trial, April 7th, 8 a.m. in person at the court. Do you have any questions at this time, sir?
Yes, ma'am.
What's the question?
This has been a very hard thing to deal with my family, and I have not been able to be home. It's been problems since I have not been home. I've been following everything that was told to me to not to be around my son, and it's my wife had to quit her job, and I have not been able to be at home. And this is something that's never happened to me.
What's the question for the court, though?
I want to be able to come home. I don't know. It said that I can't come home. Is there any way that we can lift the I don't know, the protection or
There's no contact order?
yes, ma'am.
Okay,
Because
okay, let me figure out what's going on, because I did not arraign you. I do not, this is my first time ever seeing this file in my life, so I don't know, and there's not even an affidavit of probable cause in here, so I couldn't ascertain much about the allegations. Is he married to the mother of the child?
Excuse me, I couldn't hear you.
Okay, you're married. I was asking your attorney if you're married to the mother of the child.
No, we've been together for 16 years.
You're not married, but you've been in a relationship for 16 years. And
Yes, ma'am.
residing with each other for 16
Yes.
years. And the alleged victim is his child.
Yes, it's my third.
Is there CPS involvement at all?
The CPS, the CHM, the MH. I'm sorry, but CMH and everybody is involved in everything.
I think the child in question is somewhat troubled child who has been working with CMH and other services.
Is there a protection order from the family court? That's what I'm asking.
I don't believe there is.
No, there's not. It's just one incident.
Okay, let me stop you, because I don't want you to say anything on the record that could be used against you, okay?
Yes, ma'am.
I recognize this is one charge, so I understand that. However, what I'm gathering, and again, I'm operating with limited facts, is this is an issue that involves a teenager, troublesome, community mental health is involved, allegations of some physical contact, correct? Okay, and so, where is the, so we're sending for final pre-trial to see if there's going to be an offer. Okay, I think I would need to have some communication with the mother of the child. I don't know what the conditions in the home are, and if there's no protective order from the family court, then I'll allow him to return home with peaceful contact. I don't necessarily need the mother or the person to contact me. I think the attorneys can flush that out as long as she's not objecting to it.
I think looking over the police report, I think I'd prefer to speak to the victim before.
I'm allowing you all to flush that out.
Oh, gotcha.
Yeah.
Thank you, Your Honor.
That's why I said I don't need to have it on her in the record. I'll let you all deal with that. And then if there's no issue, and then I don't have a problem amending it, but you all need to flush that out first.
We'll do that. Thank you, Your Honor. Sorry, I was reading and listening at the same time.
No worries. Mr. King, your attorney and the prosecutor is going to look into that and see if I can amend the order safely to allow you to return into the home pending this matter, okay?
Thank you. Could you tell me, is there any?
Can I tell you what?
I was just trying to figure out, because this has been a long 20 days or 30 days, whatever it's been, without being at home. I was just trying to figure out, is there a certain time limit, or, because I will call in 5 minutes and try to figure it out, because it's been a problem without me being at home.
You said you would call in 5 minutes. That's wonderful, because you probably are available in 5 minutes. But I can't tell you when the prosecutor and the public defender will be available, because they're in court right now dealing with other matters, and they are the ones who need to make the call.
Okay. Should I
So
have?
I can't give you a time limit. You stay in contact with your attorney. You have Mr. Raleigh's contact information?
Yes, ma'am.
Okay, you stay in contact with him, and then when he's out of court today, and he has to be back here this afternoon as well, by the way. But when he's available, he'll make that call and then get with the prosecutor's office so that they can flush this out to make sure that the court is advised as to how to properly proceed. Because in this particular case, the concern that the court has to balance is the safety of the victim. Okay, not the
Yes,
fact
ma'am.
that your wife doesn't have a job or that it's been rough on you during this time. The court has to balance the safety of the victim. Okay,
Okay. Before I just want to know, is there, this whole thing this incident is over me trying to get some help for my son.
Stop.
He is,
Let's not
and
talk
I've
about
been,
that right.
I've been talking to everybody that I can. Okay, I apologize. All right. Thank you very much. And
and
I'll
he's
get,
just trying to keep you from saying anything that could be used against you, because we're on the record and the prosecutor can hear everything you're saying. And everything
Okay.
you say, they can use against you.
Okay,
Okay,
thank you.
thank you. So allow them to work this out, and hopefully it's worked out in your favor, but we don't know. You're all set for today.
All right, thank you. All right, thank you.
Yep, you're free to go. Your attorney will call you.
Okay, thank you.
You're welcome. I thought I saw, maybe it's not ready. I thought I saw Mr.
You did step in, you stepped
Oh,
back out.
he's talking to somebody. There's some other people already?
There's here for,
I believe.
Scruggs.
Oh.
No, I have, there's also Mr. Jeffrey Smith.
Jeffrey Smith and who else?
Might also be worth it to just put this off.
The family
So
of
with
Chase.
Mr. Cozen, and this is Jeffrey Smith.
Oh, okay.
You know what I'm saying?
Yeah.
So, sorry, but I'll talk about peaceful contact. You can come home, but even if that makes it easy for them to work this thing out too. We'll see. Is he going to? Jacob. Is he going to?
For Mr. Roberts, Desun Roberts.
You, I think I was showing you. Oh, I had to write a note.
Who's addressing the alcoholism? That tells me he's working on being better than this one.
Gail's been counting down. The record in the matter of the people of the state of Michigan versus Chase Scruggs 25-00045. Council appearance.
Good morning, Your Honor. Matt Nagel for the people.
Good morning, Your Honor. Dustin Kuntz for Chase Scruggs. I'm in the courtroom. He is appearing via Zoom.
Okay, this matter was scheduled for pre-trial. This is for computers indecent dissemination. I believe he does have another matter.
That's right, Your Honor.
Okay. Yeah, one count computers using to commit a crime, count 2 intentional dissemination of sexually explicit visual material. Was there an offer on this?
There's no offer at this time, Your Honor.
How do you want to proceed?
Your Honor, we'd like to set this for a final pretrial.
We saw on March 3rd.
March 24th at 8 AM.
Does that work for you, Mr. King?
Your Honor, that my wife is a teacher. That's her spring break week. We're going to be out of state.
So you think because your wife gets break, you get a break? No.
I was gonna say that's harsh.
Usually how it works, right?
March 31st at 8 AM.
She's still on spring break then.
No, I'll be here.
March 31st, 8 AM.
Jury trial April 14th at 8 AM.
Does that work?
Yes, it does.
April 14th at 8 AM for jury trial, both 8 AM and in person at the court. Mr. Scruggs, did you hear those dates?
Yes.
Do you have any questions for the court? Any additional matters for the record?
Not for people, Your Honor.
Your Honor, I know so as you noted, there's another matter for my client. In this case that's set for today, he is on a PR bond. We were last here for arraignment on this case and a bond violation arraignment on the felony case. He revoked his bond. I know my client would like to address bond in that other matter. It's set for a bond violation hearing on the 21st when we have the prelim.
21st of this month?
That's right. So next Friday is when it's set next. That's when it's set for prelim and the substantive bond violation hearing. I don't know if the court would entertain a request for bond. Even though that file is not before the court right now.
So you can make your motion.
Your Honor, the court revoked bond. So the allegations are that my client drove by the complainant's house a few times in the days preceding the arraignment on this matter, and I retrieved my client's phone before he was able to go up before he went up to jail. I was able to go through his Google location history. It is physically impossible for him to have been the person driving past the house on 3 of the 4 occasions, and even the 4th occasion seems very unlikely. I haven't had a chance to provide all of this to the prosecutor yet, but the likelihood that he's going to be guilty of those bond violations is slim, based on his location history, and I finally did receive the photographic and video evidence that was referenced in the incident report, and it shows a white car. I mean, that's all it shows is a white car, and not a white Mercedes with a black gas cap, which is
which would have been very distinctive.
Yes. But from my view of things, you can't see a black gas cap, you can't see a Mercedes.
I haven't seen it. The prosecutor's seen it.
I haven't seen it, Your Honor, but I was going to inform counsel that it looks like there's also a stalking charge that's in review. I'm gonna try to
another charge.
Another charge, Your Honor. But however, to be candid, this is an allegation from December 14th.
Okay.
So
can someone grab me? Can you grab me the other file? A stalking charge from December 14th.
yes, Your Honor, and that's not been issued yet. This is a warrant request. This is review status. I'll take a look at it today and decide whether or not there's any need to issue charges on this. But just with respect to this defendant and the victim, it does sound like there's some ongoing unwanted contact. I don't know about the evidence that counsel was referring to with respect to the K-53 violation. There may be some credit to that. However, I would just ask that we wait until the date that I think it's next Friday to deal with it then. So I have a chance to review it.
There's some video evidence that, because The court has to rely on information they're provided. And so I was provided information that there were multiple occasions that were on video that showed a very distinctive vehicle, that being a white Mercedes with a black gas cap. I don't think there's a lot of those roaming around the Lansing area. And so if there's video that shows that, for me would be some pretty substantial evidence against Mr. Scruggs if he's the owner of a white Mercedes with a black gas cap. I could care less what his cell phone record really says, because that doesn't mean he was the driver or not. Maybe he didn't have that cell phone. I have more than one cell phone. I don't know. Or it could have been maybe someone else was driving his car past her house. If this is that car, that's what I'm saying, which would still be a bond violation because he can't cause a third party to be in contact or intimidate her. And so, however, if you're saying that this evidence, that the report was allegedly uploaded with this evidence from video footage, and I noted that at the time that I addressed the PA 53, and you've obviously gotten that evidence and you reviewed it, then you all should go in the back room and review it together. And then maybe that'll enlighten you. And then you can advise the court as to whether or not you believe that this is a vehicle that is descriptive as to the vehicle that Mr. Scruggs owned or not, which would make me feel differently about this particular bond violation. Not so much about the totality of the fact that I have a home invasion first of domestic violence, a computers in a intentional dissemination of sexual explicit information, and then a new case coming for alleged stalking. That's a whole nother issue. But as it relates to the bond violation, which is what caused me to revoke his bond, I think that you all need to go in the back room and flush that out if you have the video.
Yes, thank you, Your Honor.
We can do that in just a moment. Let me take this case before I let him leave.
Okay, thank you, Your Honor.
Sounds good. And we have Mr. Smith, is that Mr. Raleigh's client?
Yes, Your Honor.
On the record in the matter of the people of the state of Michigan versus Jeffrey Smith, file number 25-00093 SM, appearance please.
Good morning, Your Honor. Matt Nagel for the people.
Jacob Raleigh on behalf of Mr. Smith.
We have a bond violation. Why is that? Let's see. Does he have the new charge?
There is the city of Lansing case resulting from the bond violation trespass case.
It's already been issued. He doesn't need to be arraigned on it.
It's set for pre-trial.
Okay, so it's been arraigned. Okay, sounds good. This was scheduled for a hearing. She's already been arraigned on this bond violation. Because he was arraigned on the 25th by Magistrate Milmore. He pled not guilty.
Yeah. That's what's telling you. You were passing me. We got notification. It's telling you the charge.
I have do not commit crime while released. I have another one, do not commit crime while released. The two bond violations I have in here.
That's the email.
Well, I get that, but this is why this bond has not been revoked. These have been set for hearing today by the magistrate, or though she arraigned him on those. Are we prepared to do a hearing on these?
Your Honor, I suppose my request would be that this be held out as at least one of them has resulted in a misdemeanor case. And the other one potentially could be, but it has not been framed yet.
I'll just say that I mean, whether or not this is held out is certainly within the discretion of the court. I know the court rules allow that request. I will point out, however, that LPD Care, I spoke with them today. They've been trying to get in touch with the victim for the contempt hearing. We've been unable to reach them, so I don't have a witness for the contempt hearing today anyway.
Did you do a bench warrant on this?
Looks like on the 29th.
It's not in the file.
It was done on the 29th of January.
Actually, it looks like it was sent to the clerk's office either. It was entered in. It's not in jail. Yeah, so it was never entered in the lien or sent to the clerk's office.
It was sent to the clerk's office. They are attached to the files.
It's not in JIS. It's not in JIS. It's not in the
That
file.
means they didn't.
It's not in the file either. There's nothing on here that says I revoked the bond. I'm assuming it's have to be an email. Who signed the bench warrant? You have on a GPS tether, sir? You speak up so I can hear you?
Yes.
Is it charged?
It's not charged.
Why not?
When I got arrested, they never gave me the charge back. And I have no way of contacting them.
They never gave you the charger back. What do you mean?
Police, when I got locked up,
Oh, you saying when you got locked up, they took the charger?
they took the charge and never returned it.
I'm not sure how this GPS tether works. What does a charger look like?
That's on my ankle.
The charger. It's a cord?
Yes.
And so when you got arrested, they took the cord
They took them, they never returned.
downstairs?
Yes,
And so when you collected your things, you asked where the cord was?
yes, I did.
And what did they say?
They said this is all my property.
Why did they take you with the cord?
I don't know.
And so you were arrested, I believe, January 25th or something? Let's see. January, looks like
Yes, it might.
24th. '21st and 24th. Okay, let's see. This is Judge Simmons. How are you? I'm doing well. I have a person in my courtroom, Jeffrey Smith, who was in custody. He said he was arrested. And at the time he was arrested, which was back in January, he had this tether for charger. And that when he was released, he did not get that back. You all don't have to just have a charger to GPS tether. He has the tether on. He's still wearing the tether. He just said that he doesn't have the charger. So he was already on bond for me with the GPS tether since the 11th, and it looked like on the 20th, to the 21st, he was arrested on something else. Okay, no problem. Jeffrey Smith. Okay, sounds good, thank you. Okay, so they don't seem to have a charger down there. They said it would have been put in your property. You need to contact the tether company. You just gotta get a charge, otherwise you're not compliant with the bond condition. I actually issued, I revoked your bond. It just never, the paperwork never got properly dealt with, because I didn't know what was going on. And so if you got GPS tether, which you were ordered, I think you were arranged by Judge Ward, is that correct? Or Judge, Magistrate Faulkner ordered GPS tether. And so if you're on tether, your responsibility is to keep it charged. So I don't know what happened to your charger. You need to contact the tether company and see if you can get a new charger. And have your attorney help you make contact with them, okay?
Yes, ma'am.
Okay, I expect you to do that today. Otherwise, I will have to revoke your bond to make sure you're compliant with the tether requirements, okay?
Yes, ma'am.
Okay, and then as to the underlying charge, what are we doing, counsel?
I'll be requesting final pretrial.
March 24th at 8 AM. April 14th.
You have a question, sir?
No, I just, I mean, I can't go home, I can't change clothes.
What do you mean?
'Cause
You're asking me this?
No, you asked me, oh, no, it wasn't a question.
You say you can't go home and change clothes? Why not?
'Cause I can't, I have to tell them it's a victim involved.
Okay, well, there's been a no contact order in place since January 11th. So you're saying you were in the same clothes since January 11th?
Yes.
So you haven't gotten ability to get your clothes?
No.
This person lives at the, you are living at the same address, is that what it was? Okay, well, typically the court will rely or allow you to enter once, usually with law enforcement. I don't see where that was allowed. And also, I don't think law enforcement's really interested in helping people get their things. However, how about this? Do you have contact with the victim, Mr. Nagel?
And I believe in this case, Your Honor, we've been having trouble with getting in contact with the victim. None of the numbers we have here to work.
Okay, I was gonna say, because then what should have happened, or if we can get contact, we can make arrangements for a time for that victim not to be there, so you go get your clothes. But they don't have contact information. If you have some contact information, you should provide to your attorney. Maybe it's different from what they have.
I don't know.
Okay, sounds good. Okay, well, unfortunately, there's not much I can do other than try to move the final pretrial up quicker. 3 add a slot for final pretrial earlier in the- February 24th for final pretrial. And that will require the victim to appear in person, okay?
So was it February 24th or March 24th?
February, I just added a slot because of his situation.
Oh, okay, thank you.
February 24th. And then we'll continue the PA 53 matter.
So schedule that for the 18th.
Yes. When you contact the tether company, just let them know what happened, that it was lost during a subsequent arrest and you need another treasure. Any additional matters for the record?
Oh, Your Honor, thank you.
No, Your Honor.
You're all set. Welcome. We're giving him a notice right now, because I think of the notice he has filed for the 24th.
It's 24.
Let me see what you got. We gotta make sure you got the right stuff in here.
You just wrote it down.
We don't want you to, no, we'll get you the fresh one. Thank you, so you don't get confused. You're all set.
Have a good day.
Same to you. Okay, Mr. Nagle, we're off the record if you want to go meet with Mr. Jones.
Okay, thank you, Your Honor.
Mr. Scruggs, can you see us?
Yes,
Okay.
yes, ma'am.
Okay, and you have family here, they wanted to know if you could see them.
Yes, I can see them as well.
Okay. Okay, on the record again, in the matter of the state of Michigan versus Chase Scruggs. I actually now have file number 24-03567FY. And the parties, well, the defense counsel made a motion to address the bond, and counsel went off the record to just meet and look over some evidence. I'll let Mr. Nago address the court.
Thank you, Your Honor. Just with respect to the PA 53, it's the court's bond. People would be happy to put on evidence if the court prefers. However, to be fully candid, the evidence would be testimony from the victim regarding what she thinks she saw. There is video evidence of a white sedan driving past her house, but it doesn't look like there's more than that. So with respect to proving a bond violation beyond a reasonable doubt, defense counsel has other evidence that certainly would raise some reasonable doubt. I'll let the court decide whether or not the court wants to move forward with the PA 53. If the court does want to amend bonds so that the defendant is released, we can prevent future issues if the defendant is put on a GPS tether with an exclusion zone of the victim's house. And then we can leave the matter set for the exam next Friday and continue from there.
I'm gonna reinstate the bond, and I've already ordered GPS tether. It looks like on the other matter. I'll order GPS tether on this and be consistent with the zone. Just trying to see if I put 2,000 or 1,500 feet. Okay, not within 1,500 feet of wherever the victim lives, works, or goes to school, or does any sort of business. Do you understand that, Mr. Scruggs?
Yes, ma'am.
You're not to have contact directly or indirectly with Olivia Shook. Do you understand that?
Yes, ma'am.
I need to appear to all of your next court dates. All your other bond conditions will continue as originally stated at the time of your arraignment. Any additional matters for the record?
No, Your Honor, thank you.
No, thank you, Your Honor.
Thank you. You're all set. We'll see you on the 21st of this month on the felony.
Very good, thank you.
Thank you. I think that's all we have for the morning.
That's the morning docket.
Okay, sounds good.
Thank you, Ms. Simmons.
You can let the deputy know you're all set.